Madam Chairman, we're live.
Thank you. Welcome to our BOE meeting for June 26th. We'll start with the Pledge of Allegiance. I pledge
Allegiance to
the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Thank you all for joining us today. This is our second day of Board of Equalization, and we will get started this morning with YCAP. And from YCAP, Amanda, are you going to be our contact?
Yes, ma'am.
Okay, you've got the floor.
We appealed it because we marked a box wrong that showed that we didn't have the apartments at the correct percentages, but I submitted the documentation of income that shows that we meet the state statutes for the units being under 60, 50, and 30%. And then that was included in the packet that Ms. Leeper sent with which units met each of those criteria. So again, I apologize for the error on our part. There was just a box that was checked incorrectly.
Perfect. I'm excited to hear that this year you guys will qualify. So, within the lease? I know there's a question also in the lease where there's the ability to, if there's
The catastrophic clause, yes, they did an
Okay,
addendum
okay,
to their
perfect.
lease and they did submit that.
Right.
So that's taken care of, as long as it's in their application for every year.
Does anybody have any questions for Amanda before we move on to the assessor?
I'm good.
Okay.
Anyway, so Amanda submitted information yesterday that we had requested, the income information for each tenant in their unit. She submitted everything that we needed. Christy was able to work up and just double check the math. Units 1, 2, 3, and 6 meet the 60% of the median income in Valley County or less. 1, 2, 3, and 6, and then units 7 and 8 meet the 50% or less. Units 4 and 5 meet the 30% or less. So now that all 8 units meet the proper income limits, and we have the catastrophic clause, I would request that you reverse your original denial from their original application and give them a 100% property tax exemption for 2025.
So we are approving the appeal.
We are approving YCAP's appeal, yes.
Okay. Perfect. All right. If there are no more questions, I would entertain a motion.
I'll make a motion that we change our denial for the YCAP to a complete exemption.
It's been moved and seconded. All in favor?
Aye.
These ones you don't have to sign.
Up next on my schedule is Trinity Pines, or are we?
Thank you,
that one
Amanda.
is-
That was short and sweet, Amanda, but thank you for getting us the information.
Thank you guys for your time. Have a great day.
Hey, you too. Bye.
Bye.
Thank
That
you.
was not
Thank
till
you,
8:30,
everyone.
so
Thank you.
Thank you.
And here is
Trinity
the-
Pines is not until 8:30, so I'm assuming we're doing some of these.
We're gonna do non-personals. Yeah, here is the county and the appellant's packet on that, the original.
What's next? Trinity Pines?
Yeah, hold on, guys.
Leaper, no, they're not until 8:30.
We're gonna do some non-personal appearances in between before the schedule. He's a phone hearing, so we'll have to call and put him on speaker.
Okay.
And we have his cell phone number to do that.
Okay, and if you'll tell us who, so we can pull up the correct package.
Oh, let's go with Chris. AU 79 River Ranch LLC. This is Alan Bloxham's 2 houses that he recently constructed on deep into Flat Creek in there that are set right on the river.
Can you tell us if this was the original email or do we have an updated one? We got a bunch of updates yesterday, so I don't know if we're looking, which email we're looking for.
Look for SL 2510. Here, I can try to see what I think these only get. Yeah, the just once. I had to send you an update to the YCAP appeal because things changed.
Got a bunch of updates yesterday. Okay. So we need to contact him. And he's expecting our call.
No, he's a non-appearance. Would you like me to move some of my stuff? Okay, do you want to present?
Sure.
This will be Chris's first presentation.
I can stand up.
We're easy peasy.
We're easy, okay.
Go ahead.
Good morning, board members. We're talking about appeal number SL 2510. The property owner is Alan Bloxham, and it's AU 79 River Ranch LLC. The subject property address is going to be 12610 Flat Creek Road. It consists of 15 acres. 2 acres are being valued at full market value. It also has a 1,392 square foot home, graded as very good in average condition, built in 2022. This parcel also has a 666 square foot living quarters with an attached 40 by 48 garage, graded as very good in average condition as well. Below are the values for the last 2 years. Do you have?
They do.
Okay, perfect. And the appellant offered an appraisal dated January 16, 2025. But after reviewing all 7 comparables from Mr. Bloxham's appraisal, I found his appraiser used 2 comps from 2023 and 5 from 2022 and failed to time adjust these outdated sales. The appraisal did not include any 2024 sales. And then there should be an attached spreadsheet for comparables.
For the county comparables. Also, I might add, the houses sit fairly close in proximity. So when I talked to Alan on the phone regarding this property, he was concerned that they weren't using 2 acres. And I said, yes, but Alan, didn't you tell me a couple of years ago that you were going to fence off 2 acres to keep the cows away from the houses? And he said, well, yes. So when I went on GIS, I think that we're pretty close to that 2 acre mark. And that it's standard operating procedure to take a home site for each dwelling. And because that second dwelling that has the large garage, but it does have 600 plus square feet of living in it, we are considering it a small dwelling with a large attached garage.
Is it an ADU with the garage?
I'm assuming, I think so. I mean, the garage is huge, and the living is almost 700 square feet. So it's just a second living quarter, you know, for when people come up and stay. But anyway, he agreed with me. And then the other thing that I went over with him, people who are receiving, that they have 2 homes, if they kind of get a discount on their the 1 acre home sites. So without that discount, each one of his acres would be valued at almost 395,000 each, because he's in an excellent land grade and he sits on the Gold Fork River. I mean, right on the river.
Right on it.
It's a beautiful location. Instead of being valued at 394,000 plus per acre, he's being valued at 226,000 per acre because of the discount, he has the 2 1 acre home sites. And we do that for everybody in Valley County that have the 2 acre home sites. They just kind of get that discount. So after you look at the sales, and the sales are all below 1 acre, and then you look at the sale prices, you'll see that we've been
More than fair.
more than fair. So I would request that you uphold the 2025 assessed value that was printed on the assessment notices.
Right, any further questions for the assessor?
No, seems fair to me.
Entertain a motion.
Oh, thanks. Just write it.
I would move that we deny the appeal of AU 79 River Ranch LLC.
Second.
It's been moved and seconded. All in favor? Aye.
Aye.
And he, just so you guys know, he didn't have, after I split out the values on the two different structures, he was fine with the improvement value. He was only concerned about the land, just so you know.
Thank you. Good job.
Thank you.
Craig, you want to do Mark Bottles?
Oh, certainly. Oh, I thought he said no.
Madam Sis, can we get the commissioner to sign that?
Oh, yes, thank you, Doug. Apparently I need more coffee this morning too.
I got decaf.
Get that stuff away from me.
I need coffee too, obviously. I'm going, what are you giving me?
He wake you, Sherry.
Okay, so this one.
Awesome, thank you.
All right. Go ahead.
Good morning, this is Appeal CM 2516. Property owner is Mark Bottles. Property address is 1778 Crescent Drive in McCall. It's lake frontage. The subject is pay at lakefront with 71.8 frontage and 250 depth. We have it rated at fair and average condition. The effective year is 1980. It's an older home. The owner claims their methodology was a 2,213 per square foot with a total value of 2,611,235. They're saying that's too high and they wanted to lower it down to 1831.79 a foot. So we ran some comps. Their comps were not lakefront. The two comps that they gave us, they weren't on the lake. So we ran them, and you can see off to the right of the sheet that I provided, the per square foot, third from the right, we're right in the median. And then if you go to the far right on the total value, we're also in the median. So luckily enough, we had some good comps on the lake.
Yeah, I mean, like, I was looking at some of those people that were selling on the lake, that are in the realtor deal this morning. It's like, oh my goodness. Little 2,800 square foot house, 5 million.
Yeah, they're really
Oh,
going
yeah.
up. And the problem is that they're going up and they're tearing them down.
Well, sure.
And they're building that home price back into the lot.
Mm-hmm.
So our lake frontage has gone up this year, but according to Anthony, we're still undervalued.
We're still about 10,000 per front foot low.
So
It's a lot.
Are we still within our 10%?
we're getting
We
there.
were trying to be as conservative as possible, but stay in compliance. But Mr. Bottles or whomever prepared the appeal, they didn't even use lakefront comps. So,
Why would you not use lakefront?
because he's trying to get a lower value.
Sure he is, you know, it's like, come on, man. What do you think, we're dumb?
So,
Well, that's
It's-
my question. He is saying that Diamond Street is 52 feet of lake frontage with a shared park, and then Mill Road is lakefront.
neither one of them are
No.
lakefront.
They don't use the factor with lake frontage pricing.
Their
Look
prop,
them up.
their property does not touch the lake.
So they have the advantage of the view, but they
Yes.
don't actually own to the waterfront.
Correct.
But they have people using the park in front of them.
And that would be a disadvantage.
Yeah.
Mm-hmm.
They're priced differently.
So your recommendation is deny
The
that?
recommendation is to leave it as it is, and we think it's fair. We're right in the middle. We're not up, we're not down, so.
Motion,
I'll make a motion that we, on CM 2516, the marked bottles to, what would that be? Deny that?
That
Deny the
you would
appeal.
be denying the appeal.
Yep.
If you're gonna leave it the same.
moved in second, all in favor?
Aye.
Thank you.
That'll work.
Where are my reading glasses?
No, don't do that.
Back up, it was there for last week.
Okay, so this, so those are the two that were separate scenarios. We received 3 more appeals from the West Mountain folks regarding the common area issue with the boat docks with the 153rd, if you remember. Oh, Neil, you weren't here. So we have 1 out of the 3 that wanted a personal appearance. I scheduled it for 11 o'clock. His is just, he's the one that has the RV hookup too, right, Noreen?
Correct.
So his is just a touch different because there's a RV hookup involved. But Mr. Dillon and the Thomas Family Trust are pretty much the exact same thing that you guys discussed yesterday, and they are non-appearances. So would you like to hear all 3 of them at 11 o'clock basically, or would you like to do the 2 non-personals now?
Let's do the non-personals now.
Yeah,
Okay, Maureen?
agree.
Do you want to give Neil just a brief synopsis?
Maureen can.
Okay.
She can speak to it more fluently than I can, I believe.
Well, that's true, right?
Since she did the hours and hours of research on this.
Several months ago.
Remember Neil wasn't here yesterday. All right, so we will be looking at John Dillon, appeal number CM 2514, and Wade and Lavia Thomas Trust, CM 2515.
My cover letter pretty much explains it. Neil, what had happened was it was discovered that there was a large portion of land over on West Mountain that is considered a common area. And there's 72 parcels within 3 subdivisions and some rural ground out there that all own a share of this common land. It's been taken to court and judged, and I'm still reviewing that, and that's another subject. But there's a boat dock on this that we discovered, and it's been there for over 20 years. And the most fair and equitable way that we felt to distribute the value of that boat dock that sits on this common parcel was to have it on each of the 53 parcels that have ownership of the boat slips.
Yeah, it's complicated.
Yeah. So there's only 53 slips, 72 parcels. So what Mr. Dillon and Mr. and Mrs. Thomas are contesting is the value being put on their parcel instead of being put on the common area parcel. And I didn't feel when I was going through it, I didn't feel of putting it on the common area parcel for the simple fact that those are the land itself is owned with shares. These boat docks were separate. They buy them and then they pay a maintenance fee. And I'm not sure if it was monthly,
Probably
or not,
annually.
or annually.
So who buys the boat dock? These 2 families or whole share.
So 53 out of the 72 parcels
Right.
have bought a boat slip. But the other remaining parcel owners do not have a boat slip. So that's why we opted to take the full value of the boat dock, divide it by 53. And that's how Noreen came up with the $3,525 in value
Mhm.
for each one of the people that have a boat slip. So, because it wouldn't be fair to assess the other folks that don't have one for the boat dock,
I'm following you.
okay? So,
We decided yesterday that they have a year from now to figure all this out and bring it back for an appeal next year. But for now, we will let it ride.
I did email one of the president of the common.
the homeowners
whatever it
association, if
is,
you will.
Yeah,
Go ahead.
and let him know that, it was denied, but I would like to actively work with him to have it resolved and have it done properly in both our eyes, to see how we can come up
Next year.
for next year.
And the legally, you cannot assess fees to an HOA. HOAs don't pay property values on common areas, but it does talk about improvements. And so what we're doing is trying to assess on the improvements, which is different than the land value. So they're not being assessed for that parcel of land they own. They are being assessed for the
The
improvements.
improvements.
Which is the dock.
They can either move it over to the HOA and do that separately
And through this,
this year, or they can leave it as we've done it
So if
now.
they move it over to the HOA, then we're out of it. Is that correct?
it's technically not an HOA. They want you to believe that it is.
Ah,
It's actually a rural piece of ground. It is not platted common area. And Noreen has been starting to get more documentation through this process. And I suspect it will have a land value perhaps next year, but that she can work with Mr. Miracle on all that.
Some of the sales that I have discovered from past 21, 23, and I'm sure when this one was, I think 23. It indicates right in the description that a designated included in your purchase price. So you're buying the boat.
mhm.
So, and in each of these, it states something similar to that.
You buy a boat dock, it's like,
You're buying a boat dock. So you've purchased a boat dock. It's not part of your share. They did provide their certificate, I guess you could say, Common Area Association, where they have a share in this Common Area Association, Inc. Incorporated. Mr. Dillon provided some very helpful information on his, that if you look at his, let me see where it's at in my pile here. I highlighted it. So in his letter for the reason for his protest, this was inserted only on his, not on the other ones from yesterday and today, but the letter itself is the same, except for this one little spot. And it says that the president determines the dock allocations, and he's the owner of 2 parcels. So he owns 2 shares, but he only has 1 boat dock. So to be fair and equitable, I feel that the way I went about doing the 53 boat docks was the most, 153rd was the most equitable way to
Treat everyone
to
fairly.
treat this, just as Mr. Dillon says, he doesn't have 2, and he owns 2 parcels. So, or 2 shares, I should say. So I feel that, I feel the way that I went about this was the most, like I said, fair and equitable way to be able to assess and have the taxation on the structure that is applied to that.
so basically, all 53 are splitting this cost.
Well, each one are getting $35.25.
It works out to $8 in taxes.
Right.
We used last year's levy rates.
And to have that, that's
That's a huge amount.
it's a huge benefit to people when they're
Yeah.
purchasing those slips.
In the letter, they do say that it doesn't meet this statutory definition of real property. which it does because it is an improvement which is accessible and taxation is.
That's out here on Cascade Lake?
Yeah.
Not slips out there.
Oh, yeah. This is, they own part of the lake.
have
They
their own-
actually have,
Oh, really?
It's by French Creek subdivision. So it's on the Cascade end.
Yeah, down on this far end.
It's got an airstrip.
Mm-hmm.
it's just north of Anderson Creek Road,
Okay,
but south of God's Acres.
my goodness. Okay, well, so what are we gonna do? We're gonna deny this? Is that what we're doing? I'll make a
Deny, and if
motion.
you, do you want to do, hold on one second, do you want to do both of them at the same time, or you want separate motion?
I think if you were to reference both appeal numbers, it would be sufficient. Clerk
So
Miller?
it would be 14 and 15.
Okay, I'll make a motion that we deny the appeal for CM 2514 and CM 2515, John Dillon and the Wade and the Bay Thomas Family Trust.
It's been moved and seconded, all in favor?
Aye.
I am.
Thank you for all the hard work. I look forward to a resolution before next year.
She'll keep working on it.
This might be the best resolution when they get around to it and really realize what they're doing.
That's convoluted.
Have another one.
Yeah.
Oh, yeah.
It's 53 people.
Security.
What a mess.
It is.
Yeah.
It is, yeah. I'm sure my next step with the common land portion, I'm going to have to go to Army or so to see if they can read the 1985
Mm-hmm.
Do it first.
court decision and see if I'm reading it correctly.
Artie loves doing that.
So, hoping that I'm reading it correctly. And
Look at Artie smiling back there.
Arnie's deep breath.
I know. And Arnie's like, I haven't had to deal with her yet. Great.
I am gonna guess that noise that we might have heard was.
No.
Oh, no?
No.
Oh, no, because we're gonna call him. Okay, this is gonna be the telephone hearing, Sherry, for Trinity Pines, Church of the Nazarene.
Randy Peterman.
Randy Peterman is the attorney's name, and his cell phone number
I've
is,
got it here. Hold on one
see
second.
it? Okay.
I've got to dial 9 or 8 or something, don't I?
8.
8.
Trinity Pines, that's the Nazarene camp
Mhm.
south of here.
We're in litigation currently, so we're kind of waiting on an answer from the judge from last year.
Mr. Peterman, this is Sherry Moppin, Valley County Commissioner. Good morning. So we've got you on speakerphone, and in the room is our assessor team in order to hear your appeal.
Good morning, Randy.
Good morning.
All right, you are up. If you would like to go ahead and present your case for appeal.
Thank you. I understand we have very limited time this morning,
Oh.
so I'm not going to repeat any of the arguments.
Mr.
we made last
Peterman?
time around.
If I can,
Yeah.
Mr. Peterman, if I can,
Yes.
I forgot to swear you in. If I
Oh,
can,
I'm sorry.
yeah, no worries. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you. Now you can proceed.
Thank you. I'm going to limit my oral argument to issues raised by a U.S. Supreme Court case that was entered just exactly 3 weeks ago, and is called Wisconsin Catholic Charities versus the state of Wisconsin. It is a U.S. Supreme Court case. It was decided unanimously 9-0, and it deals with the fact that Wisconsin violated the First Amendment rights to freedom of religion of the plaintiff by denying an exemption requested by these Catholic charities. So I'm going to concentrate on that. I would note that the Valley County packet of information for both years does not indicate that the rights of Trinity Pines identical to the factors here. Under Wisconsin law, the religious entity must control the real property, and that property must be operated primarily for religious purposes. So it's very, very similar to the facts of this case, but decided under the First Amendment as opposed to FERPA. In that case, the Catholic Church was an umbrella. Catholic Charities was an umbrella organization that provided job placement, coaching for people with disabilities, community-based training, and so on. The original decision by the Wisconsin State Labor Commission, which would be analogous to what this body is deciding, ruled that the exemption was not available, concluding that even if Catholic Charities' motivations were religious, its activities were not. I would note that this is a continuing theme in that case, and basically the U.S. Supreme Court ruled that motivation is more important than the actual activity that occurs. And if it's religiously motivated, then the exemption should be granted. That case went to the Wisconsin Supreme Court, which affirmed, and again, it looked at the services provided and concluded they were not primarily for religious purposes, but didn't look at the intent of the religious entity. And basically, that court ruled that Catholic Charities' activities were not under applicable law operated primarily for religious purposes because they neither engaged in proselytation nor limited their charitable services to Catholics. And again, Trinity Pines maintains that that is analogous to what's going on here. And again, the Wisconsin Supreme Court wrongly decided that the activity should be the primary issue, not the intent. That got the case to the United States Supreme Court, which affirmed that the question of the exemption raised to strict scrutiny as the burden of proof. That is identical to what FERPA requires of this body. And the holding was, quote, whether to express and inculcate religious values through worship, proselytation, or religious education when performing charitable work are, again, fundamental theological choices driven by the content of different religious doctrines. And because that unnecessarily involved the state in deciding the religious beliefs of the charities, and because Wisconsin had looked at the activities rather than the intent, the court unanimously overruled that decision and declared that Wisconsin's treatment of that exemption was contrary to the First Amendment. I would just note that the analogies between the U.S. Supreme Court case and this case are clear, and that the U.S. Supreme Court made it very clear that a public entity cannot inquire into the religious beliefs of a church. There was a concurring opinion from Justice Thomas. He talked about the church autonomy doctrine, and that the state definitions of religious activity or a church, quote, cannot impermissibly disregard the internal governance structure as defined by church law. That's my presentation. Thank you.
Thank you. Anyone have any questions?
Well, I do have a question for Mr. Peterman. It's not really a question, but our whole premise is that when you, it doesn't matter what kind of entity that's a church camp or whatever, that rents their facility to an outside entity, and they are not a church religious entity at all. They're just providing a venue. And that's what this whole premise is about with these exemption. Why are we having this discussion?
My response would be that according to the Catholic Charities case, it's not the activity that should be the focus of this group. It is the intent of the religious organization. And if we look at what this court decided in terms of, what this group decided in terms of activities, that is the wrong place to look to determine an exemption issue. You need to look at the intent of the religious organization, and then the case holds that the county should not become unnecessarily involved in religious matters or in making fine distinctions between religious organizations. That would be my response, sir.
I think because we are right now in litigation, then I think that, we will allow the legal process to bear, and we will wait to see what the response is from the judge in this case. So I think because we are
Yeah.
under the same
I'm
time.
sorry.
Go ahead.
That's exactly right. And the Valley County prosecutor, Brian Opie, and I attempted to just delay this issue until the last year's case has been appealed to Valley County. That was not allowable by the State Tax Commission. And so we just decided we better proceed. We better be compliant with all the timing issues for this hearing and others, and that then we would probably just suspend that matter until we have the decision from the Valley County Court as to last year. So I agree with that.
Agree.
Okay, perfect. Yeah, and we are just trying to preserve your appeal rights. So if,
Yeah.
okay, thank you very much. Next is Assessor Leeper.
Good morning, Randy. I appreciate your arguments. Mr. Peterman has introduced the Wisconsin case, and I would just like to touch on that for a moment. It was a U.S. Supreme Court case, and it is actually has to do with unemployment tax, not property tax. As we know, those are two separate matters. I believe that the case says if you are a religious employer and you are operating your organization primarily for a religious purpose, you are exempt from unemployment tax, period. This has nothing to do, that case has nothing to do with property tax. I would also like to state for the record that FERPA does not apply in this case at all. We are not inquiring about anyone's religious beliefs at all. We are only looking at the use of the property to see if they qualify for a partial exemption or a full exemption. We have to interpret the statute with the presumption that it is valid. And we need to continue to interpret the law the way it is written until we have further clarification from the court. As you know, we are waiting for a written decision from Judge Scott. But for Trinity Pines and Quaker Hill to preserve their appeal rights for 2025, they had to submit an appeal. The Board of Tax Appeals said that they would not honor any stipulation, that we actually had to go forward with an appeal. And so that's what we have done here today. And we are anxiously waiting an answer from Judge Scott, of course. The other case is a district court case in the state of Idaho between the First Presbyterian Church of Idaho Incorporated versus Ada County Board of Equalization. The case had to do with property tax exemptions. And in this case, which is CV 01-23-11470, it is the same issue that we have here in Valley County. It says basically if the property is leased to someone else, it is not an exempt use. I believe that this court case absolutely 100% applies to this appeal. I have included it in your packet for your review. So in waiting for Judge Scott's decision, I would ask that you uphold your original decision of 209 days exempt and 156 days of commercial use that we have assessed and sent an assessment notice on. Thank you.
Do I have any more questions for Assessor Lever?
Nope, I'm
Not,
good.
I would entertain a motion.
I would move that we deny the Trinity Pines appeal.
Do I have a second?
Second.
I moved and seconded. All in favor?
Aye.
Aye. Thank you, Mr. Peterman,
Thank you.
and
Thank you.
we will wait to hear what Judge Scott has to say.
Okay,
Thank you.
guys.
That's frustrating.
All right. Well, who are we hearing next?
Just a second. Let me give this to Doug.
Oh, do I need to sign that one?
No,
Okay.
all right, so that takes care of that one. So our next, we can do Highway Chapel. He is a non-personal appearance. So we can take care of that one. So that would have been appeal number KH 2509.
That's the one next to the Pancake House.
Yes. Yes, it is, sir. So hopefully you guys had time to read through Mr. Roberts's appeal packet. The second page, it's a narrative addressing the things that we had mentioned of why we felt that the entire property should not qualify for a property tax exemption because it is not being used exclusively for religious purposes. If you will remember, the Board of County Commissioners approved a partial exemption for this property. And instead of days, we used, so the church building, we believe, is being used for religious purposes only. And of course, the land that sits underneath the church. So I think it was 0.22 of an acre that sat underneath the church that we exempted, as well as the actual church building. Mr. Roberts lives in the house next to the church, and they have two outbuildings behind the house that we are assessing. As you know, in 63-602B, it says that the property must be used exclusively for religious purposes. I have made a site visit to the property, well, numerous times throughout the years. My most recent visit was on, I think it was April 24th. And I observed many vehicles. I observed what appeared to be people showing up to go to work, getting instructions and or materials, and then leaving to go, is what it appeared to me. They had personal vehicles there as well. Mr. Roberts states that he is the pastor of Highway Chapel, and he is additionally self-employed, which I agree with that statement. I believe he has 3 different companies: Lesco, McCall Supply, and North Exteriors. So he has those three companies that show that are active with the Secretary of State. Mr. Roberts states that his business property is at 300 Cron Lane. I have also been to that property numerous times throughout the years. And then he also states that he has an office in a downtown McCall location, which is in no way associated with Highway Chapel. I had reached out to Mr. Roberts by email, and I had asked him for the address of his office for his businesses downtown McCall. He failed to respond to my email. On every single Secretary of State filing, they only refer to a P.O. Box 2663, McCall, Idaho, as their business address and or 300 Cron Lane. There is nothing on 300 Cron Lane other than it appears that they dump some construction supplies waste on that property. I have included numerous pictures in your packet that we'll get to. There is a camp trailer that has been there for years. I'm not real sure if anybody stays in it or not. I have pictures of, it looks like he had logs delivered and they're cutting them up for firewood. There's a wood splitter there. And just recently, the mini excavator that was sitting on the property next to the church or behind the church building previously is now sitting on the 300 Cron Lane property, and it appears that they're digging. I'm going to assume they're starting to prep the property because Mr. Roberts has taken out a multi-family use building permit that he stated the estimated cost of construction would be $999,000. But he's also claiming that that is where he runs his business out of. As I sat and watched his property at 215 and 217 North 3rd Street on April 24th, people were coming and going. It was clear that they were, to me, it was clear that they were showing up for work, getting what they needed supply-wise from the outbuildings and off the property, and then leaving to go to work. I also observed a white car, which I do believe is their personal vehicle, probably his wife's would be my guess. In all of the Secretary of State filings for Highway Chapel, for Lesko, McCall Supply, and North Exteriors, take away Highway Chapel, excuse me, they use the P.O. Box 2663 and they use 300 Cron Lane consistently. Mm-hmm. On Highway Chapel's recent filing, they used either the 217 address, except for on Terry, his wife, they actually used the P.O. Box 2663, which indicates he's been very careful not to cross over with any of that information. And he even included that filing in his packet to the board. And that would be behind the pictures in his packet. The first line, Terry J. Roberts, which I believe is his wife, used the P.O. Box 2663 address, which is the business address for his other three companies. Barbara Roberts, I believe, is his mother. We did verify that her P.O. Box is 266. I thought maybe it might be a typo because it was missing the 3 on the end, but it isn't. P.O. Box 266 is actually Barbara and Larry Roberts' P.O. Box. Another interesting fact that I discovered was all of their vehicles, which I believe there's 8 of them, including 2 trailers in that, are all registered through the DMV using the P.O. Box 2663. So it has become clear to me that they use that P.O. Box not only for their businesses, but for personal use as well. And since they use that PO box on the Highway Chapel annual filing, to me, that they're all associated. He's claiming that the property is not used for business and that he drives his work truck home and parks it there. I don't doubt that, but there are business dealings going on the property. Let's see. There has also been an ASAP portable toilet there. I have pictures back from 2023 where that porta potty was sitting. He's claiming in his statement to you that that porta potty is there because there was a plumbing problem with the church. I have to tell you that porta potty sits clear on the south boundary, basically the boundary line next to the old pancake house. And if I was going to have it on my property because my congregation needed to use, have access to the facilities, I believe that I probably would have put it on my north property line. The pictures that I have included in your packet also show the construction materials. He goes on in his narrative to you guys, saying up until last week, the church had plumbing issues, but apparently it's fixed now. He addresses, though, the skidster, that it's there for snow removal, which I don't doubt that. But I think it's probably a multi-use piece of equipment. He moved his excavator from the church property to his business property at 300 Cron Lane recently. He says, since I live in the parsonage, I do come home in my work truck and park there. He says the red and white pickup was an inheritance from his late grandfather and is a restoration project. I actually agree with that. That truck hasn't moved in many, many years.
So he is calling it a parsonage because he's the pastor of the church.
Well, yeah.
Is that correct?
Correct. If he was only using the property for religious purposes, the entire property should be exempted, but he's not. We believe that he's using the church for religious purposes only, but we do not believe that the rest of the property is being used exclusively for a religious purpose.
How do we deal with other churches that have parsonages, though?
Other churches that have parsonages that the pastor lives in it, and that's what he does.
Right.
And he doesn't run a business off of the property, does get a full exemption. He would as well if he wasn't conducting business off of his property. There's construction equipment, there's construction supplies. He goes on to say that the reason the tar machine was sitting on the property, and he sent pictures, is they were re-roofing, not the whole church, but just that little stoop right there, back in 2023. And I agree. I agree with that statement. But he has now
Still
moved the
there.
tar machine.
Yeah.
And the dump trailers have construction debris. One of them might have firewood in it, but the one that I saw had construction debris in it, sitting at the property behind the church.
It
Okay,
looks like now we've got a parcel on Cron Lane that's becoming a dump ground. So we may have a code compliance issue.
yes, ma'am.
'Cause I remember him being in here discussing 300 Con Lane because of conflict with the city and blah, blah, blah.
Oh, when he took the building permit out?
Yeah,
Mhm.
yeah.
Yeah, I think he had to comply with something. I don't know for
The
the
city
whole
was
story.
being ridiculous.
'Cause I think he put it as a multi-family
Mhm.
use, because I believe that his elderly folks are going to live in that home.
That's correct.
And someday when they have passed, I believe he wanted to rent that portion out.
Mhm.
So therefore, I think the city of McCall might have imposed some stipulations of some nature.
They did. They wanted an ADU attached to it.
So,
Let's go ahead and complete on their property values. We can go down a rabbit hole on the rest. So,
So the portion that we assessed was the home that him and his wife live in, the 2 outbuildings out back, and the land associated with that, because it is quite clear that there is construction activity on the parcel, and there has been for quite some time. If you'll notice in the pictures that I provided.
I think that I've heard this every year in BOE since I've been here, so 6 years now.
And
If it was just a one-off, this is construction that's underway this year, we would not be having the same conversation for 6 years, so.
so I did include pictures of the Lesco Enterprises LLC website, where he uses the PO Box 2663. A narrative, what they do, the business search for the entities. I also looked up the addresses on Les's driver's license and his wife Terry's. And I believe Terry's physical address says it's 215 North 3rd Street, and the mailing is PO Box 2663, which is the company's PO box. And on Les's driver's license, it shows his home address is 300 Cron Lane with the PO Box 2663. So I think I have exhausted every avenue between the vehicle registrations, the driver's license information. I don't believe that they ever applied for a homeowner's exemption, because for years they were 100% exempt. I do not believe that they have filed for a homeowner's exemption, so I do not have that document to look at.
We denied it last year, didn't we?
He did not apply last year, but the year prior, he appealed. Well, he was denied the exemption. He was denied the exemption. He appealed to the BOE. He was denied at the BOE. He went on to the Board of Tax Appeals and was denied as well. So then last year, he didn't even file an application.
My.
And then this year, he applied again. And so we gave him a partial exemption on the church building and the land associated. And then we are assessing the rest for this year, and now he's taking us to BOE, which we are here today for. Anyway, I have included pictures of all 3 of his companies' websites and information. Picture of his home. Pictures of trailers behind the church building, dump trailers. The excavator, now these are pictures here are in 2023. The same excavator is now sitting on 300 Cron Lane. And the tar machine is actually backed up to the stoop in 2023 that they were putting new tar on. Dump trailer with a cover on it, the red and white pickup that has been sitting there for years, as well as the skidster. And then if you will look just over the rack of the red pickup, you'll see the top of the ASAP porta potty sitting over on the south property line, and that was in 2023. The picture of the detached garage, and if you look to the right of that garage, you will see lumber and construction materials. Let's see, another picture of the excavator. Okay, now we're moving to pictures of 300 Cron Lane. As you can see, the vegetation is overgrown, doesn't really appear like much is going on there. Pictures of the rocks in the entrance to the property. The camp trailer you can see on this next picture, just at the right, kind of nestled into the trees with a pickup. And the blue tarp is covering the wood splitter with a log deck of logs. A little bit better picture of the logs on the next one. And then, as you can see, there's a bunch of stuff kind of stored, chain link, various construction materials, but it's extremely overgrown. Now, these are all pictures taken in 2023. The last time that I visited the property was on April 24th of this year. And I observed a tar machine, 2 dump trailers, skid steer, scaffolding, a white car, a red and white pickup with a rack, a SAP portable toilet, work shed, ladders.
So,
And this is on, and then I viewed those on the property where the church and his house is on April 24th of this year. I took numerous pictures, and as you can see, the tar machine is no longer backed up to the stoop that they put new roofing, new tar on in 2023. There's still some scaffolding sitting there, but the tar machine's been moved. I took pictures of the vehicles. You can see the same,
This is Mr. Peterman calling back.
okay,
Okay, hold on just one moment. This is Sherry Moppin. Mr. Peterman? No, he's not there.
anyway, in the picture that I took on April 24th of this year, you'll see the ASAP portable toilet is still sitting in the very same place. The trailers have been moved around, of course. You see the ladders leaning up against the garage in the back. You can see the tar machine has been moved and parked in a different location away from the stoop. And the propane tanks that are associated with it and the dump trailer is now parked next to those with a cover on it. It appeared that there was construction, like wasted supplies that probably need to be taken to the dump. The next picture is of 300 Cron Lane. You can see that the red excavator has now been moved to this property. It appears he is digging out what I'm going to assume is a foundation area since he took the building permit out for the home that they intend to build. This picture, since it was taken in April, the vegetation was knocked down through the winter. You can see all the things that he has stacked there and that are associated with construction. Another picture of the excavator, and then kind of his pile, his dumping pile that he's been dumping waste, I guess, on the property from his jobs.
well, what is your recommendation?
My recommendation is that we uphold the commissioner's decision from his original application this year. I think it is fair that we give him an exemption on the church building because we believe that he is using it for religious purposes only.
Are they having church?
They are having church on Sunday evenings at 6 p.m.
I saw some people coming out a week or two ago, and they're all dressed up nice, so they must be having church.
We believe that he is.
Must not be church. Nobody dresses nice to go to church.
We believe that he is having church services on Sunday evenings at 6 o'clock. We do not believe that he is using the entire piece of property exclusively for a religious purpose. I have enclosed, of course, the Ada County and First Presbyterian Church District Court decision with your packet for your review, stating that if it's not used exclusively, then it's considered a commercial use. I would ask that you
Ready.
uphold the assessor's assessment for 2025.
Deny the appeal.
I'll make a motion for the, my glasses on, for AH 2509, Highway Chapel, McCall, Idaho. I make a motion, we deny the appeal.
It's been moved and seconded. All in favor?
Thank you, Sue.
I need to sign that one.
Madam Chairman, it's a property tax exemption, so there's nothing to sign for this one.
Okay, up next is not until 9:30, so do we have another one to fit in the middle?
Thank you.
Mhm.
I'll bring them right back. Thank you.
M6 family property? Give you 11.
Okay, sorry, getting caught up here. So the next one we're going to hear will be at 9:30. It looks like we can take a little break. It is the YMCA, and they are going to be on a Teams hearing.
How about the M6 family property?
They are a personal appearance
So,
at, let's see, 10 o'clock.
so we'll go ahead and take a break now.
Yes.
Okay.
I could use one.
Clerk Miller, if you will take us off.